Good evening, everyone. My name is Ethan Moore. I'm the chairman of the Monongalia County Republican Executive Committee, and joining us tonight for our fifth in a series of 5 virtual town halls are candidates vying for seats on the West Virginia Supreme Court of Appeals in Divisions 1, 2, and 3. We welcome our viewers who are joining via Facebook Live and YouTube Live. Some of you may also be watching on Twitter via Periscope. We welcome you to our broadcast tonight, and we hope you find it informative and worthwhile. We do have 1, 2, 3, 4, 5, 6, 7 of the candidates who are vying and will be on the ballot on June 9th. And so we have an excellent turnout, and we do believe that things will be informative and helpful. Again, my name's Ethan Moore. I'm the chairman of the Monongalia County Republican Executive Committee, and we're going to go through our group of panelists, introduce those panelists to you, and then after that, we'll give each an opportunity to speak. So just so our viewers know, as we're proceeding tonight, you can post your comments and questions in our comments feed there on Facebook Live and on YouTube Live, and as time permits, and as we're able to, we'll pose those to the panelists. We do have a bank of 5 previously approved questions that we will be posing to the panelists to stimulate conversation. And so if we are unable to get to a question that's brought to us via a live viewer, please know that it's not, we're not censoring anyone's speech. We're just doing our best to get through this in a timely manner. So with us tonight, we have Justice Tim Armistead, who is in Division 1, Justice John Hutchison, who is in Division 3, Judge Jim Douglas in Division 2, Judge Joanna Tabbitt in Division 2, former Justice Richard Neely in Division 1, and Attorney Chris Raines in Division 2. We had also anticipated having with us Judge Laura Dyer, but we understand that inclement weather in rural West Virginia has caused her to be unable to join tonight. She was hoping to be able to join by phone, but that's been precluded by inclement weather there where she's at. So she sends her apologies, and I'm sure she'll continue to try. So without further ado, or without other fanfare, we're going to start and let our panelists introduce themselves. First up will be Justice Tim Armistead in Division 1. Justice Armistead, give me one moment to get your mic unmuted. There you go. You have the floor, Justice.
All right. Well, my name is Tim Armistead. I'm currently the Chief Justice of our West Virginia Supreme Court of Appeals. And I don't know if you want me to go into the opening here or just introduce myself at this point. Did you want?
No, by all means, go ahead and provide. Go ahead.
Opening?
Just, yep.
Okay. All right.
Yep. Go ahead.
All right. Thank you. I just didn't want to break the rules here. So, well, obviously, I think all West Virginians know that our court has been through a very challenging period over the last couple of years. And over the past 18 months, it's been my honor to be a member of our state Supreme Court, and this year to be the Chief Justice. And I think we've made tremendous progress in restoring the confidence, the integrity of our court, of making people trust the court, which is incredibly important when you're talking about a court that affects their lives each and every day. We have put in place policies to ensure that the past events do not happen again. We have worked with the legislature to rebuild their trust. We have reduced our budget and been much more efficient with taxpayers' money. In fact, we gave $10 million of excess money back last year. This year's budget that was just approved with working with the legislature is actually $4 million less than the budget was 5 years ago. We're making the court what it should be, what it used to be at one point in the people's minds, and it got off course. And I think what we have done in the last 18 months has been historic. I don't hear people talking anymore about what are you going to do to fix the problems in terms of integrity and ethics. They're talking about the future of the court, and that's what we need to be talking about, and how it can ensure that the people's lives in West Virginia are affected in the way that they should be affected by their court. So I really would appreciate the opportunity to continue this work. We have a great choice in front of us to either continue to move forward or go backwards. And I think the people of West Virginia wants to go forward, and I would love to be a part of doing that.
Very good. Thank you for joining us tonight, Justice Armstead. We appreciate your time, and we'll try to respect your time and move along in a manner that's respectful of that. Next up will be Justice John Hutchison. Mr. Justice, give me one moment to get you unmuted. And you have the floor, sir. Go ahead.
Thank you very much for having me this evening. My name is John Hutchison. I'm from Beckley, West Virginia. I've been on the court 17 months. I joined the court in January of 2019, having been appointed by Governor Justice. Prior to that, I was a circuit court judge for 24 years. The Chief Justice stole a little bit of my thunder in terms of my opening statement, but I'll kind of repeat things that I think need a little bit more emphasis. You know, we went through a horrible period of time in 2017 and 2018. In fact, one of the justices referred to it as the year that was not awesome, and it truly was not awesome. But once we got through all that headache and heartache, and the court became complete in January of 2019, we immediately began to move forward. The court has taken on many, many new initiatives, including approximately 11 policy statements. The court didn't have a lot of written policies, and you would have thought that you really didn't need a policy that says you can't use a company car to go play golf or things like that. But apparently we did. And so we've adopted all these policies and put them in place and made them public so that the public can understand exactly what we say we're supposed to be doing and then checking what we're supposed to be doing. The other thing that this court has done, and I have had the privilege of being involved in, is an outreach program, a more open outreach accessibility by the court. You know, there are several of us who have gone to schools. I think the number is somewhere around 20 different schools that we've taught classes in during the past year, trying to bring our young people up to date and let them know what's going on. We are also pushing our specialty courts, the family treatment courts, the drug courts, that sort of thing. Those things are all progressing, and we are taking very, very positive steps. And I believe that I have been an integral part of that. And it is my sincere hope that we can continue to do what we need to do, take the perception of politics out of the court, because the court is not a legislature. The court is a court, and the court is supposed to interpret the laws and apply the laws. So I think we've made a really good start on that, and we need to continue it. So having said that, thank you very much.
Very good. Thank you, Justice Hutchison. Next up will be Judge Jim Douglas. Mr. Douglas, give me one moment. Okay, and you have the floor.
Probably people pay you to keep me muted there, I would say. I'm Jim Douglas. I'm a Braxton County native. I graduated law school in 1977. I was actually part of the 76th class, finished up then. I am 69 years old. I am a father of 3, a grandfather of 6, and been divorced. As far as the background goes, I have got a undergraduate degree from Morris Harvey College. That shows how old I am. It's now referred to as University of Charleston. I've also got a master's degree from WU and a law degree from WU, where I served as a student bar president, 76 and 77. I have been primarily, over the last 39 and a half years, I was a practicing attorney. I was a prosecuting attorney in Braxton County. And I've tried about every type of case that you can think of, except a tax case, probably, but I have done that in incidental to a divorce. My practice has been family law. That is where my heart lies. I take the position that we need a family law judge, someone with family law experience on the West Virginia Supreme Court of Appeals. I'm a family court judge. I'm the only family court judge that's running. I know circuit judges are running. I know attorneys are running, but I'm the only family court judge. and my experience is extensive. I think I can bring to it not only, practical experience, because I think that's what we need on the West Virginia Supreme Court, with all due deference and niceties to the two sitting justices here tonight, is we need people that have tried every type of case. We need people that have gone into the courtroom. We need people, particularly though, that have tried family law cases. Because if you look at the statistics that are published at the court's own website, besides those that are at the National Center of State Courts and the U.S. Census, is that the most civil appeals, the highest percentage of civil appeals is filed every year are family law type cases. If you look across the breadth of all the cases that are filed, including the criminal law cases, we find that the family law cases that are filed in the West Virginia Supreme Court of Appeals numerically are greater. For instance, in 2018, there were 104 more family law cases filed than criminal cases. In 2019, there are 84 more. It usually averages over the last 10 years about 92 of those, 92 cases more than criminal cases. I have tried cases in 44 of the state's 55 counties. I've also made arguments Supreme Court of over 40 cases. Most of them were family law cases, including when we had to apply for certiorari before the rules of appellate procedure changed in 2010. I want to bring not only that practical experience, but the family law experience back to the Supreme Court, because what we don't realize, what most people don't realize, is there are two 12-year terms there. There is one 4-year term. And for the next decade and a half, it only takes one more justice on the sitting court to establish a majority that will set the law. And I think 12 years is too long not to have somebody that has a family experience to be a component of that court. There needs to be somebody that's had that experience, can say whenever 5 justices are looking at a family law case, hey, what about the kids? What about this happening? And to ask me, when you tried these type of cases, what did you do? So that's what I want to bring to it, boots on the ground. That's basically it.
Very
Any questions,
good.
didn't
Thank
even
you,
come up.
Judge. Next up will be Judge Joanna Tabbitt. Judge Tabbitt, you have the floor.
Did you unmute my mic? There, I guess so. Well, thank you all for
I
the
did unmute your
opportunity
mic.
to be here this evening. My name is, can you hear me now? Okay, we're unmuted. But my name is Judge Joanna Tabbitt, and I'm running for Justice of the Supreme Court of Appeals, Division 2. I am a lifelong West Virginian, and I'm running for office to improve life for all West Virginians, because I believe that now more than ever, our court needs proven qualified judges with circuit judge experience, because that's what Supreme Court justices do. They review the work of circuit judges. And I believe that the individuals that are elected to the bench need to possess the integrity, character, qualifications, and sense of fairness necessary to lead the court in the next generation. And as a circuit court judge for over 5 years, and as a courtroom litigator for 28 years before that, I have a wealth of experience to bring to the court. I worked for the court when I first got out of law school and was a personal law clerk. I left and went to the Attorney General's office, where I worked for 2 years and practiced almost exclusively in front of our Court of Appeals, representing county prosecutors and state agencies. After I left the Attorney General's office, I worked at a law firm, one of the largest law firms in West Virginia, where I was a partner for years and tried scores of cases throughout West Virginia in state circuit courts and in federal courts, and argued cases in front of the Supreme Court. I have spent my entire life in a courtroom. As a circuit judge, I'm a member of the Juvenile Justice Commission. I have been appointed by various chief justices to the business court, and I'm currently a member of the mass litigation panel, where I'm serving as the lead resolution judge on the landmark opioid litigation in West Virginia. And I'm also the presiding judge in Kanawha County's juvenile court. I have had the distinction of being appointed several times as an acting Supreme Court justice. I know firsthand the work of our state Supreme Court, and I also know that it is not a position for on-the-job training. I ran for this office in 2018, and I'm sure Chief Justice Armstead remembers that was a compressed election cycle and a fractured field. And I came very close in that race. That was my first statewide race, but I was encouraged because I believed our message resonated with the voters, which is why 1 year ago today, which would have been about a year to the original date of the primary election, I filed my pre-candidacy papers to run for this office because I am committed to being your next Supreme Court Justice, and look forward to the discussion that we have today. Thank you.
Very good. And thank you, Judge Tabbitt. Next up will be former Justice Richard Neely. Mr. Neely, give me one moment. Okay, we have you unmuted. The floor is yours, sir.
Good. Well, I am probably the most strident person on this program tonight. I'm Richard Neely. I came originally from Marion County. I am a graduate of Dartmouth College in economics and of the Yale Law School. When I got out of the Yale Law School, I think I graduated the 12th of June, and on the 15th, I was in the Army at Fort Sill, Oklahoma. So I served a year in Vietnam as an Army artillery captain, got the Bronze Star, came home, ran for the legislature, and served in the legislature from Marion County. And then at the age of 31, I was elected to the West Virginia Supreme Court of Appeals, where I spent 22 years and spent 5 terms as Chief Justice. And I can tell you that the West Virginia Supreme Court doesn't work worth a hoot right now. It is in terrible shape. It now takes between 19 and 28 months to get a case through the West Virginia Supreme Court. It lets in huge amounts of trash, which does terrible damage to litigants. Every case is given an appeal, a full appeal, where clerks sit there and generate mindless garbage of pseudo scholarship to turn out an opinion that tells you that the sun rises in the east. It used to be that trash got popped out within about 5 months or 6 months. You had 4 months to perfect your appeal. The court does not follow Article 8, Section 4 of the Constitution, which tells us how to do an appeal to the West Virginia Supreme Court. The thing that you learn from physics, particularly subatomic physics, is that anytime you have a dynamic process, the action of measuring that process is liable to influence the process itself. Thus, a chap named Heisenberg taught us you can't measure both the speed and location of an electron simultaneously, because whatever you use to measure the speed changes the direction, and whatever you use to measure the direction changes the speed. And that's what's happening with the West Virginia Supreme Court of Appeals. We are changing the nature of decisions by being incompetent, slow, and not diligent. It is taking far too long, and it is far too bureaucratic. When I ran the Supreme Court last, which was in 1994-95, I did it with 19 people, 7 of whom were clerical. Now, to my count, there are roughly 125 people in the administrative office, taking up an entire building on McCorkle Avenue. Used to be called the Diversified Mountaineer Building. And yet, with all of this money spent and bureaucracy, we are not getting fire on the target. We are also not applying any kind of quality control with regard to the rest of the judicial system. Under the Judicial Reorganization Amendment of 1974, the West Virginia Supreme Court is responsible for the entire system. We are not making an effort to provide quality control. There are circuit courts into which you can go and have your case vanish into a black hole because a judge can't get a decision on a motion out in less than 9 months. So all of this needs to be changed, and that's why I'm running for the Supreme Court.
And very good, sir. We thank you for joining us tonight. Next up will be Attorney Chris Rains. Chris, give me one moment here. Okay, you have the floor.
Good evening. My name is Chris Rains. I am a proud native of Putnam County. I graduated from Marshall University and I went to the law school at the University of Akron School of Law. That's where I started my career in prosecution at the Summit County Prosecutor's Office in Akron, where I got a ton of experience in 6.5 years. I even got to try my first death penalty murder case before I was 30 years old. That taught me how to put together large, complex cases. So in 2006, I moved back here to work for the United States Attorney's Office in Charleston as a special United States attorney, working in high-intensity drug trafficking cases. That was a federal grant that was eliminated. So in 2008, I was hired at the Putnam County Prosecuting Attorney's Office, where I've been for the last 12 years. I handled the majority of the felonies, many of the murders, and the majority of the child abuse and child sex abuse cases, which I do have a passion for. As you may see, I am the only one on this forum who is not a judge or a former judge, but I think that's a good thing. I think I bring a fresh perspective to this panel, and I will bring a fresh perspective to the court. And in my role as a prosecutor, I'm glad that Judge Douglas brought up the statistics of the court. The greatest number of cases that go before the Supreme Court are criminal appeals, which are because the Supreme Court is the court of last result, and abuse and neglect cases. For some reason, those cases are put into the family court cases, probably because they deal with families. However, both criminal appeals and abuse and neglect cases are generated by prosecutors. So my role as a prosecutor will give me the experience to look at those types of cases, which are the greatest majority of the cases that the court will see. In 20 years of holding people accountable as a prosecutor for their actions, I will also bring that skill set to the court and bring accountability to the citizens of West Virginia. I am the sole conservative in Division 2, and that is evidenced by my endorsements from the West Virginia State Republican Party, as well as West Virginians for Life. And I'd like to tell the people out there that if you want a court with conviction, elect a prosecutor.
Very good. We thank you, Attorney Chris Rains, for that. I just want to take a moment again to welcome our viewers who are watching. We do have viewers joining us now on Facebook Live and YouTube Live. Obviously, that audience grows and ebbs and flows, but welcome to our viewers who are watching via Facebook Live and YouTube. We welcome your questions in the comment fields there. We will pose those to the panelists as time permits. My name is Ethan Moore. I'm the chairman of the Monongalia County Republican Executive Committee, and tonight you're watching a virtual town hall among panelists of candidates who are vying for seats on the West Virginia State Supreme Court of Appeals. This is the fifth in a series of 5 virtual town halls that our committee has put together. And so we welcome the panelists, and we're trying to be brief. We're trying to be courteous and respectful of everyone's time. And so we're going to go in now to our first question that was a bank question. These are questions that our committee prepared that we would use to pose to these questions, just so everyone can kind of get themselves arranged here. Our order, the first 3 will be Chief Justice Tim Armstead, second, Attorney Chris Rains, and third, Justice John Hutchison. The question is, what will you do to restore or instill confidence in the Supreme Court? And first up will be Chief Justice Tim Armstead. 1 minute. Okay, you have the floor. You're unmuted and ready to respond.
All right, well, thank you. Well, I think we've done a lot already, but we need to continue doing what we're doing, which is to do our work ethically, to do it with high ethical standards and high standards of integrity, to impose those standards on every person who works for the court and make sure they're being followed. And I think we've gone, as I said, come a long ways in doing that. But regulations and policies are only as good as they're enforced. And so it's very important that we enforce them, and we have an open court, transparent court, where people know whether we're enforcing them or not. I think part of the problem with our court in the past is that there was no openness and transparency. It was sort of a ivory tower up in in the wing of the Capitol, and people were not a part of it, and they didn't view it, they didn't see it, they weren't a part of watching what took place in the court, and that's incredibly important. And that's why, as Justice Hutchinson has said, we went out and tried to open our court up to the people of our state. But I think that's incredibly important, that people understand and that we're accountable and transparent. Now, when we went to the legislature this year and presented our budget, the budget is only 9 line items, 9 lines in the entire 200 and some page budget of our state, about a page and a half, for all courts, circuit courts, family courts, magistrates, the probation department. All that is about 9 lines. But we took each one of those lines and went, throughout them very in great detail, and took that to the legislature and said, here is how we would spend the taxpayers' money, and here's where we've made reductions. And they were very complimentary of us. And that type of transparency is important for people to know what we're doing, how we're doing it, and for us to be open and accessible to the people of our state. Now, when you talk about what we're going to do in the future, one thing, and I must disagree with my colleague there a moment ago, and I don't want to get into the debate already, I guess, but the court is not a mess. The court is doing its job. It's doing it well. It is doing it ethically and efficiently. And it does not take 2 years to do a case in our court. The statistics are there. They're online. People can look at when the cases were filed and when they were decided. That's just simply not true. And we need to be truthful with the people of our state about the future of their court and what's going on there. And it doesn't take that long for trial. Is there occasionally a case that takes longer because of a bankruptcy, for example, that takes place, or the parties are trying to work it out and they ask for contingent? Sure. But the cases are being heard and decided in, within national averages, usually within less than a year. And abuse and neglect cases are much quicker than that, around 140, 150 days. So we put them on fast track. But I will say this, and then I'll move on and let others speak. But the reason that things were happening so quickly before was the court wasn't hearing cases. They just were issuing one sentence lines. We refuse to hear this case. The Constitution of our state is very clear, and I disagree with my colleague who said that we need to go back to the Constitution. We are following the Constitution because it says in Article 8, Section 4 that my colleague has cited, that the cases may also be decided if it presents a proper point for the consideration of the court. The court has to decide what cases present that proper point, and Article 8, Section 3 talks about the court sets the guidelines for how those cases are set. So the court decided 10 years ago that everyone should have an opinion based on the merits of their case. They shouldn't have this one sentence, we're not going to hear the case, we're going to dodge this case, we're not going to hear it. They deserve that. Whether you're a plaintiff, a defendant, a company, an individual, you deserve to know why we decided the case, as we do. And that's what we're doing now. And it does take some time. Hopefully we'll continue to do that. It's a rule of the court. That's why it's so important you have the right justices on the court that will continue to follow that rule.
Very good. And thank you, Chief Justice Tim Armstead. Next up, answering the same question will be Attorney Chris Rains. Attorney Rains, you are unmuted. You have the floor.
Thank you. Like I said before, as a prosecutor, I am very learned in or very used to rules, policies, and procedures. For 20 years, I've run my career through that. And I actually think that there have been great changes to the court under Chief Justices Walker and Armstead. I think the voters actually took the first great step in voting on the constitutional amendment for legislative oversight of the court's budget. I think that should have been done all along in keeping with the separation of powers, so that the judiciary did not exert more power than the other two branches, which is, I think, probably the reason for the implosion that it had. But just going back to the basics, under Chief Justice Beth Walker, putting forth policy and procedure and policy, procedure, and personnel manual that all businesses go by. And Chief Justice Armstead in providing a purchasing policy. So we don't have any more $32,000 couches. And also just rolling back the budget and making that transparent and viewable by the citizens. All of these brought the court to the same type of scrutiny as any other state agency in this state. And without those rules and guidelines, again, I believe that the court had too much power and there was an inequality in the branches of government. And that's what led to the problems that we had a couple years ago.
Very good. We thank you, Attorney Chris Rains. We're coming next to Justice John Hutchison. Justice Hutchison, you have the floor.
Thank you very much. I think both of my colleagues have kindly stuck to the same theme that I believe we need to stick to, and that is you improve the court by improving accountability and accessibility. I agree with the Chief Justice that my understanding from the statistics that the average case life from the time a notice of appeal is filed with the Supreme Court is somewhere around 290 to 310 days. Granted, there are going to be cases that for some reason or other get delayed longer than that. But if you look at the average is somewhere around 290 to 310 days for a case to be fully resolved with a decision issued. But accountability is letting the people know that the Supreme Court of Appeals is going to do its job. Its job is to review cases and controversies. Its job is not to legislate. And I think what you have seen in the last 18 months with the beginning of what the five of us have referred to as the new court, what you've seen is a desire and a real positive focus of the court to stay within its constitutional guidelines. We deal with controversies. We only deal with controversies, and we don't make policy unless there is a question that is unresolved and needs to be dealt with. And if you review the cases in the last 18 months, you will see that this court has stayed very, very much inside its own lane in terms of being the third branch of government. We've got an obligation to protect the public, which I think we are doing by giving them a decision on a case when they feel like they have a need for a decision. We've not tossed cases simply because we don't believe it has an appropriate issue of law or it's something we don't want to address. The key is that we tell people why their case is being decided the way it is. The other way you do that, you improve the court, is through accessibility. We've got to be out. We've got to be available to the public so the public can ask us hard questions, just like tonight. We're here, we're ready to answer questions, and we're ready to state our positions on things. And the court has got to continue to do that. And a part of that accessibility is education. We have to continue to educate the people in the state of West Virginia of what the court's function is and what they can expect when they come to the court and what they should not expect from the court. So I think, again, the general trend of accessibility and accountability all fit together in that's how you improve this court. We've taken a huge step forward in doing that in the last 18 months. And hopefully I can continue to help the court to do that. Thank you.
Very good. Thank you for that answer. Next up will be former Justice Richard Neely. And just so the two following can prepare, the order for that question will go Neely, Douglas, Tabbitt. So former Justice Neely, one moment. You are unmuted and you have the floor, sir. Go ahead.
Well, as we used to say in the Army, It doesn't make any difference how shiny your tank is or how well turned out your soldiers are. If you don't get fire on the target, you're not doing your job. And I'll give you a concrete example of failing to get fire on the target. There's a very fine family court judge in the Eastern Panhandle named Jackson, Judge Jackson. She told me the other night that she had decided a domestic case in which there was only one asset, and that was a house. Not a complicated case, but she had ordered the house given to the wife. The husband appealed. The house was in terrible condition. The wife tried to go and get a home improvement loan for $35,000. The bank wouldn't give her the loan for as long as the appeal was being processed in the Supreme Court. The appeal took 25 months. By that time, the house was a shambles and utterly uninhabitable. The roof had collapsed, the water had come in, and the house was gone. So I disagree that all of these cases are being decided expeditiously. There may be some, and there may be some fairly simple abuse and neglect cases that are popped out. But the great majority of cases are taking between 19 and 28 months. And and it's not true that we're following Article 8, Section 4 of the Constitution. Article 8, Section 4 is a very old, traditional, common law prescription. In order to get an appeal, you come to the Supreme Court and you apply orally to the court for a writ of error. The lawyer gets to come down himself. He gets 10 minutes to argue, and he gets to answer the question, how did you get worked over? I often have asked that question from the bench. And he gets to tell you in a very incisive way how he got worked over by the lower court. If, having made his strongest case, you conclude that there is nothing to that appeal, you dismiss it. And we used to dismiss 3 out of 5 appeals. True, we didn't write any big opinion, but the circuit court had handled that. We simply said the circuit court was right. Because we got rid of 3 trash cases, we could actually focus on the 2 out of 5 cases that we let in for a full appeal. And the result of that was that most cases got disposed of in 6 months, and the cases that came in for a full appeal might perhaps have taken as much as a year because of the briefing schedule. But basically, it was a much faster, much more efficient system. So what do we do to restore respect to the courts? We get fire on the target. And one way to get fire on the target is to develop a system of quality control to make sure that the circuit courts are getting fire on the target.
Very good, sir. We
That's it.
thank you for that. Thank you for that response. Next up will be Judge Jim Douglas answering the same question.
Still question,
Judge
still
Douglas?
question 1,
Correct. We are still on question 1.
because you cut out earlier when you asked designated the individuals to answer. My feeling is this, that after having all the practical experience that I've had and having been on the bench as a family court judge, and also with the sensitivity of family court issues and the pervasiveness of family court issues in the litigation landscape, I don't think that there is enough fealty or homage or loyalty paid to the principle of stare decisis. In other words, I think the court, with all due respect to the gentleman here today, have not paid a lot of attention to the predictability function, especially in family law. Whenever I had come out as an attorney and I had to advise a client, I had to tell them on a certain set of facts, the law says this, and this is going to be the likely result. What I've seen in the last 3 years, anyway, if not 4 years, has been a turkey shoot. It's been a crap roll. It's been a dice throw on what will happen with regard to the law. And again, with all due respect to the circuit judges, I mean, they are our intermediate appellate court, as it were, before we get to the Supreme Court. And I just don't see a lot of research or a lot of sensitivity being given to not only family law issues, but also all that law has developed since 1986. And especially since the time of the Whiting decision, which Justice Neely played a prominent part in terms of his dissent, which proved to be prophetic, by the way. The other thing I think that needs to be done with regard to the court too is to give it a sense that we are lessening not only the spatial distance with the public, but also the symbolic distance. I can't see why every year at one time a year under proper security measures, the East Wing, third floor of the state capitol can't be thrown open to have a media day. People can come up, 4-H clubs, kids can come down from school to go back and walk in those quarters, those hallowed hallways. Why can't they just come in and see what actually happened? We don't have to depend upon the press. We don't have to depend on secondhand statements. And they can actually see that these are real people that work here. That wouldn't interfere with the function of the court, just to have one day a year. I'd call it a media day or a public day. The other thing too is I think that the court will commend them on this. I think they've gone out and appeared in the public. I don't know whether the election cycle has to do anything with that or not, but nevertheless, I think they've become more apparent and more public, going out to events and being seen. Probably prior to 2018, most people in the public can pick the justices out of a lineup. Now I think that's helped some, but there's more to be done. And here's another thing too. Anybody that's campaigned this state knows how geographically unwieldy it is, how difficult it is to travel over 55 counties. You know, from right here to the Eastern Panhandle takes 5 hours. You know, it takes 2.5 for me to get down to Mercer County. And I don't see anything wrong with the court holding court as it's done in the past, like in Morgantown, the College of Law. I know here recently there have been some attempts to have it in Martinsburg and also down in Huntington. But there's 55 counties. What would be wrong with the court having an argument docket just one time and do it rotated among 55 counties? What I'm saying, have one in Sutton, have one in Clay, have one in Winfield, have one down in Princeton, have one in Hinton. You know, just one day to let people know that these are real live human beings and this is your court at work. You don't have to depend on an election or candidates trying to do that. The other thing is that I think this court should have 2 more things, and that's it. One is I don't subscribe to strict constructionism. That's a bunch of lawyer talk saying, well, I hear this popular saying, well, courts are to apply the law, they're not to legislate. I think that's wrong. I've got a philosophy of being an activist, and I will continue to do so if I'm elected. And that's this. If we didn't have loose constructionists, if we didn't have activists, especially on the United States Supreme Court, but in this court here, in the United States Supreme Court, you would not have had Brown versus Board of Education, Topeka, Kansas. You would not have had Miranda versus Arizona. You would not have had Gideon versus Wainwright. You would not have had Obergefell. You would not have had the Windsor decision. You would not have had Baker versus Carr. That's potentially a question here later this evening. Society changes. The document that we call the Constitution, both in the state and federal government, is organic. It's a living, breathing document, and it has to be adapted to the changing times. Yes, there are such things as the rule of law. Yes, there are such things as precedent. Yes, there are such things as equal protection. Yes, there's such things as due process, and those are going to change.
Sir, I'm sorry, we're way over on the time on that one.
Last thing, and I say one last thing. Another thing, real brief is, yesterday I made my tax returns available to the Charleston Gazette. I think every year, every justice on the Supreme Court should be obligated to reveal their tax returns to the public.
Very good. Thank you for your answer. Next up will be Judge Joanna Tabbitt. And Judge Tabbitt, when you provide your answer, then we'll have one of our other moderators come on and read a statement from Laura Dyer, and then we'll go into question 2. So one moment. There you go. You're off mute. You have the floor.
Thank you. And I'll be brief. And as it relates to instilling public faith and confidence in the judiciary, really my vision is simple. And I think it we talk about accessibility and accountability, and I will, albeit briefly, but I think our court needs to do a few things. They need to be fair. Court needs to be effective. Court needs to be accessible, and it needs to be accountable. And this all instills public faith and confidence in our judicial system. And it goes from the top down, because the Supreme Court needs to ensure and enforce. And be sure that circuit court judges, family court judges, and magistrates are all doing these things. But by fair, I mean the court should respect the dignity of all persons, irrespective of race, gender, religion, sexual orientation, or any other defining characteristic, and treat all people equally under the law. And to be effective, our court needs to apply the rule of law. It needs to apply the rule of law promptly, consistently, adhere to the principles of precedent, and also with finality. And our court needs to be accessible, and it needs to be accessible, as Justice Hutchinson discussed, with respect to court outreach and be accessible to the people. But the court also needs to be timely, and it needs to be understandable. It needs to be convenient so that people can get there. And we could talk about what the court had done through the COVID-19 pandemic, what we are doing in the judicial emergency to assure that people have access to justice. So that is critical. And of course, the court needs to be accountable. We've talked about that. The court needs to be transparent in its spending practices, and simply just adhere to principles of fiscal responsibility that we all apply in our businesses and in our home lives. And just simply, the court needs to be accountable to the people that it serves. And I think that if a court does all those things, is fair, effective, is accessible, and accountable, much public confidence is instilled in the judiciary. Thank you.
Very good. And thank you, Judge Joanna Tabbitt, for that answer. Before we move on, I do want to welcome again our viewers who are watching via Facebook Live and YouTube Live, where our audience grows and ebbs and flows, but welcome to those who are joining us. Please post your questions there in the comments section. As time allows, we'll pose those to the panelists. We're trying to limit those questions to questions for all candidates so that we don't have one highlighted over another, so that you might be mindful of that in your crafting of a question. For the time being, though, I am going to bring on Paula Martinelli. She's the secretary of our committee, and she has a statement that Laura Dyer has provided. Laura Dyer was unable to join us tonight due to connectivity problems. She's in a rural part of the state and unable to connect due to a storm that's passed through that area. She did try very diligently to join tonight, and so Judge Dyer was unable, but she did manage to get a text out, so it came to us via text. And so, Paula, I've got you unmuted. If Paula can join us, she's going to read that statement from Judge Dyer, and then when we come out of that, Kyle McAvoy, our vice chair, is going to moderate for the panelists the second question in our bank of questions. So, Paula, go ahead.
All right. This is Judge Dyer. Good evening. This is Judge Laura Dyer. I wholeheartedly apologize for not being able to connect. Despite my attempts, the last 10 minutes I cannot get through. I'm very blessed to live on a farm in rural West Virginia with all the wonderful things about a farm. That one negative is it does not take much to disrupt the phone and internet service. Sadly, I simply did not pay close enough attention to the weather tonight to make other arrangements. If any of you participated on the last call with the Kanawha GOP, you may have heard me joke that my goat crew did not churn the belt fast enough to power Zoom. Tonight, the goat crew currently is on strike due to the storm passing, and despite repeated attempts, I cannot connect. She goes on to say, I will submit written responses by tomorrow morning to the questions and would be happy to respond to any questions posed. God bless everyone, and hopefully you are having nicer weather wherever you may be. Laura Dyer.
Very good. Thank you, Paula. And again, that it's not through her. She wasn't trying to avoid us. She just was unable to due to technical issues. So coming up to us now will be our Vice Chairman, Kyle McAvoy, who's going to moderate question 2 with our panelists in the order that we have. Kyle, go ahead.
Hi, everybody. Thank you all for joining us this evening for this, and we greatly appreciate it. I'm going to go ahead and keep things moving. The second question we have for you all is, what do you view as the greatest challenges to the West Virginia judicial system, and how will you overcome them? I'm going to turn it over first to former Justice Neely. Give me just a moment here. Okay, you have the floor, sir.
Well, this pandemic is going to create a lot of utterly unforeseen legal problems. And I suspect the greatest challenge to the West Virginia judiciary in the immediate future is going to be sufficiently imaginative to come up with ways of balancing the interest of people who, for example, are heavily in debt because of obligations they incurred before the pandemic, and who are now, for all intents and purposes, bankrupt through no fault of their own, because they had to close their business or lose their job, etc. And these are going to be questions that are different in degree and in kind from what we have seen before. I just did a case for my largest client that's a big internet, wireless internet provider based out of Silicon Valley. I've been general counsel of that company for about 6 years, and they ended up owing just a little under $1 million about 2 months ago because they had made an acquisition. And they were in the situation where their customers weren't paying them, and because they were part of the Homeland Security National Emergency Communication System, they could not take anybody off of phone and internet service for non-payment. So we filed an action in federal court to ask for equitable relief under Section 261 of the Restatement of Contracts, impossibility. And one of the things listed under this case happened in Oregon. One of the things that's listed in Oregon as an impossibility is an action of the government. We filed it in federal court, but as it turned out, we managed to settle the case, and the creditor was willing to give us about another 8 months to pay off this debt without filing a complaint. But a lot of people are going to be caught between a rock and a hard place. You don't want your people to have to file for bankruptcy. Bankruptcy is a big blot on your copybook for the rest of your life. So, I mean, that's going to be one of the big challenges to the judiciary. And the rules for that are going to be articulated by the West Virginia Supreme Court of Appeals. I can't hear you. Can you hear me?
Yes, again, thank you. Appreciate it. Appreciate the answer. We're going to keep moving along here. I'm going to pass that question on to Judge Douglas. Give me just a moment here to unmute you. Okay, the floor is yours, sir.
Okay, well, what I see coming on the horizon, just out of sight, is number one, and it's been brought home in the last 2 months, is we need disaster planning plans in place before a disaster happens. A good friend of mine, Steve Canterbury, had indicated before he left the administrative office of the Supreme Court that they had actually purchased, the court had purchased a number of tomes, a number of books to try to make that plan. And with all due respect to everyone present, you know, we've had 7 administrative orders trying to keep the courts running, or at least somewhat some semblance of being open over the last 2 months. If we plan for something like this happening in advance, then it may not be as cumbersome in trying not only to administer justice during these episodes, and it doesn't just have to be an epidemiological event. I mean, it could be a natural disaster for that matter. And not only to run the courts while this is going on, but also during the recovery period and the reopening. The reopening of courts now is going to be the most challenging in my mind. And let's not let that happen again. The other thing that's going to be coming on the horizon, I anticipate will be a major factor, is after the 2020 census, the West Virginia Supreme Court of Appeals, if the legislature does not do the job consistent with constitutional mandates of equal protection, will have to redraw the congressional districts, and they would have to redraw the legislative districts if the legislature does not do it correctly. And then, of course, if the Supreme Court is hesitant or unable to act in that regard, or they see it being too political, the federal courts will draw those lines. We do not want that to happen. The third thing is that I think that we have to look at too is it was unfortunate that the case involving the impeachment established, I guess it's been referred to as the Workman versus Carmichael case, that arrested the impeachment proceeding involving Justice Workman. I'm a big believer in the separation of powers in a republic, both as a political scientist and as a lawyer and as a judge. And that case overruled a case that had been in place just for 10 years. And this highlights the problem with precedent not being observed. That was Holmes, the case of Holmes versus Clodges. And I think there's going to have to be some adjustment to establish the balance between the legislature and the Supreme Court as two of the branches of the government. The third is what I consider to be the great budgetary imagination event that will occur. A lot of people think it was terrible that the Supreme Court lost control of its budget. Of course, we did that by constitutional amendment, and the public, and it was like a reaction to everything that happened in 2018, what is called the Lawfrey era. But I think given the experience that could be available on the court, we have to take this opportunity to remedy some things, especially that may affect family law. We all saw the turmoil about the foster care funding bill in the legislature in the 2020 session. Why do we not make proper funding of foster families a budgetary item within the Supreme Court itself, the Supreme Court's budget? Just got 9 items, according to Justice Armstead, Chief Justice Armstead. Another thing is the guardian ad litem funding. It was cut during the Lawfrey era, and I don't ever think it's been restored to its sufficiency. Guardians ad litem are lawyers that are appointed to represent children in contested cases, whether it's abuse and neglect, whether or not it has to do with the custodial allocations or custody fights. The other thing is, I think we would have an opportunity to put into that budget not only guardian ad litem funding proper and foster family stipulation, but also the guardian funding for what I call FIGs. That's where a grandparent comes in, wants to be established a guardian for the children whose family or whose parents are out because of opioid addiction. Why can't there also be proper funding for daycares at court so that people can come to court? You want me to stop? Is that what you're saying? Okay, last thing is, I don't see anything wrong with having the funding in the budget too for Saturday courts and night courts to alleviate some of the delay in the resolution of cases. That's all I have to say, believe it or not.
Thank you very much. Appreciate the answer. We're going to move on to Justice Hutchinson. Give me just a second here. Okay, the floor is yours.
Well, obviously, the most immediate concern facing the court and the judicial system right now is the COVID-19 pandemic and what that is going to do in terms of creating a new normal for us. It has the potential, I believe, to answer a number of issues and create some very positive outcomes. We're learning that we can use technology to have remote hearings, and we're finding that those are starting to work out very well. It may have a tendency to ease some costs with regard to witnesses that it may have to travel, or it may be inconvenient. It may make it more convenient to schedule witnesses if they don't have to travel. But nonetheless, the issues that are facing the court right now currently are changed day to day. And thus the need for a number of different orders, initially clamping down on all the court system, and then very gradually and hopefully thoughtfully releasing some of those restrictions so that people who have the capacity and the desire to use remote kind of technology can do so. There are judges out there that are, and family court judges that are having remote hearings constantly. There are a few judges and a few family court judges that have never had a remote hearing. So we're going to have to get with those people and encourage them. But long term, I think the challenges in terms of making the system more accessible, dealing with issues, for example, the equality or lack of equality in bond decisions in criminal cases, coming up with better ways to handle abuse and neglect cases. You know, I handled, I carried them when I was on the bench in Raleigh County. I maintained a backlog of about 150 cases, abuse and neglect cases. I closed about 125 a year. That tells you how many cases I was getting out of, and that was just my 1/3 as a judge in Raleigh County. Those cases take an immense amount of time because of the rule deadlines that are charged. So maybe we're going to have to start looking at some ways to maybe expedite the hearing process and take a little bit of pressure off the judges so they can get other things done. But the other thing that I think that is going to be imperative for the courts to consider in the future is the use of the specialty courts. The family treatment courts, which are designed to, you know, we've got situations where people have to be held accountable in criminal cases and in family cases. They've got to be held accountable for their conduct. But the courts have got to come up with better and more efficient ways of trying to help these folks out so we don't see them back again. So that is an issue, I believe, that is going to be critical in the future for the courts to deal with. And that comes from the top. The leadership at the top is going to be dealing with that. And I think currently we're doing pretty well. Thank you.
Thank you very, very much. Moving along, we're going to go to Judge Tabbitt. Give me just a moment here. Okay, the floor is yours.
Thank you. And as it relates to the challenges, I believe actually that the biggest challenges are many of the ones that you discussed, Justice Hutchinson. First is, I think, the technology facing the court in light of the COVID-19 pandemic. And I've got to tell you, we've been working with it every day, and it is working. And I think that it is highlighted that, like everybody, we can learn to do things differently, and we are doing things differently. I mean, everybody's working differently. Our children are learning differently, and our courts are running and can run differently. And I think with the use of technology, some of the tools we have, and frankly, some of the things that we'll be looking at in the future, we're going to be looking at probably hybrid courtrooms where some of the parties are actually present in a courtroom socially distantly. Some of the individuals will be participating remotely. You've just got to look at these different types of things. And secondly, I think the biggest challenge too is, it's the opioid crisis. It's the addiction, and as it relates to the abuse neglect docket that the circuit courts are dealing with. And I live that, and I see it every day as a circuit court judge. And please understand that I believe these cases are critically important because the family is really the foundation for everything. But what happens is, if you talk to any circuit judge right now, I believe that he or she will tell you that 50 to 60% of their docket is dominated by abuse neglect cases, which just means that you can't get to the other things on your docket. So that's something that the court needs to be mindful of. And I think the establishment and the use of treatment courts, adult drug court, juvenile drug court, and now family treatment courts go a long way in that regard. Because statistically, we understand that if you can keep children and families together while you're dealing with parental addiction, and you can do that safely, now that's clear, you have to do that safely, that there's a better result all the way around for the family, and a better result for that individual that's trying to recover from that addiction. I think the court needs to work with the stakeholders like the DHHR, social workers, law enforcement, and recovery communities to move forward and deal with those issues. Thank you.
Thank you very much. We're going to move along to Attorney Raines. Give Give me just a moment here. There, I got you unmuted. The floor is all yours.
Thank you. The biggest challenge after this pandemic will be meeting the demands of a busy docket that will be inundated with cases that have lagged because of COVID-19. Justice delayed is justice denied to these people. They are not numbers. And real people with real problems need to be addressed in important ways, and they need to be addressed by the lower courts due to the lockdown that we are under now. The teleconferencing is working. I think that perhaps in dealing with this influx of cases because of the stall right now, teleconferencing can continue with civil hearings where people are not constitutionally mandated to be before the court. But in criminal cases, in abuse and neglect cases, I think that in-person hearings are vital and proper in those types of cases. But we're also dealing with a probation supervision problem reduced because of safety of the probation officers. We're also dealing with children in abusive households that are further in danger because they may have no safe outlets for them. Again, I agree with my predecessors that the opioid crisis and the influx of abuse and neglect cases are the main challenges that the court will have to deal with. As a prosecutor, I believe that about 85% of my cases are drug related. And again, the drug problem is probably the cause and effect to the abuse and neglect problem. So I believe that the drug and treatment courts have been successful to a point. However, during the aftercare, after the graduation from these treatment courts, that's when people are starting to slip back into addiction. I would increase the time of aftercare supervision, increase the counseling and job skills and training for these addiction courts. And I'd also look into other states, and in Putnam County, we had a pilot program with a veterans court, because we send these people overseas into the military to fight for our freedoms, and they come back with PTSD, they come back with addiction issues, and they're left to struggle and possibly die. I think we owe it to our veterans to give them a chance, give them any opportunity that we can to return them to the people they were before they went to fight for our country.
Thank you very much. Appreciate the answer. We're going to go along to the last for this question, Chief Justice Armstead. The floor is all yours, sir.
All right, thank you. Well, I agree with a lot of what's been said. We are going to have some immediate needs that are going to be crucial in terms of, we've never closed the courts. And I want to make very clear that that's been incredibly important to us all in the court, that we've never closed the courts. We have slowed the engine, so to speak, and we need to start that engine back at full throttle, and we need to do that gradually. And what we've tried to do throughout this process is listen to the medical experts. Everyone has an opinion of what should or shouldn't happen and how fast it should happen, but the medical experts really know the danger from this epidemic, and they've been very helpful. We've talked with Dr. Hubner from the National Guard. We've talked to Dr. Marsh about in terms of putting the processes in place that we have up to this point, and we'll continue to do that. But we are going to need to start back into having jury trials again and having grand juries. And we're going to do that gradually, and we're going to do it with the cooperation of the judges throughout our state, who I think are very, very eager to get started into that process. But in the long term, let me say that all the things that have been talked about kind of come down to one central theme, and it's sort of what your question was: of how do you face the challenges? Change is hard. It's just hard in a court system. It's hard in whatever system you're working in. People get used to doing things the way they've always done them. That's not slight to anyone in particular, but just people don't like change in many situations, and it's hard to affect change. When we had to go to technology, some people took off on it immediately and appreciated it and liked it and made it work quickly. Others are still struggling with it. So any type of change that you have to make, you have to lead that change, and you need to bring in the people and talk with them about how to accomplish that change. And they have to be invested in that change. And I think that's what I've been trying to do this year. One of the things I did early on was talk to our magistrates, brought in the magistrate board, and they said they'd never met with the justices before. Well, why shouldn't they? We should talk to each other and hear what they're dealing with. We need to deal with the abuse and neglect situation. And I know there are some who say, oh, let's just get a new court to do it or whatever. I don't think the circuit judges are saying to me they don't want to do them, or obviously they don't enjoy doing them because they're incredibly challenging. But they also want to accomplish what happens at the end of those cases when you hopefully get that child in a safe, loving, secure, healthy home. And they just want, they're not saying make someone else do it. They're saying to me, help us do it. And so we've been working with DHHR and with the legislature and started the family treatment courts so that there's accountability as you go through that process and you try to help these families reunify when they can. And when they can't, you get that child in another loving home with a grandparent or a foster parent or an adoptive parent until permanency can be established. So there are a lot of the things that have been talked about here that are important in moving forward. And I think the biggest challenge we're going to have is getting everyone moving in the same direction in those cases. And I think my 20 years in the legislature has helped me learn that lesson, so to speak, that you need to bring people in and you need to talk with them. And when we did the order that we just released that starts that gradual reopening, we sent it to the public defenders, the prosecutors, the county commissions, the circuit court representatives, the family court representatives, the magistrates. We brought them into the mix and talked to them about it. And not everything they suggested ended up in that order. Some of it's going to end up in different guidance documents we will issue in the future, but we listened and we tried to bring everyone on board. And that's the big challenge that I think our court needs to face in the future. And I think we've made tremendous progress in doing that.
Very good. And thank you, Chief Justice Tim Armstead, for that answer. We're going to pause here for just a moment. Welcome our viewers again who are watching via Facebook Live. I think we've dropped off of our YouTube feed by accident, so we're just going to continue going on with Facebook. If you have a question, you want to post it there in the comments. We'll pose those to the panelists here as time allows. We are going to stop for just a moment on our bank questions and go to a question because it seems relevant and timely to the other questions, the responses here by our panelists. This is sort of a synthesis of a question that came in via Facebook comments. The question is, what, if anything, should the judiciary do to combat West Virginia's drug epidemic? And so I know many of you touched on that in your response to the last question, but this is a direct question regarding that, so you have a little bit more time there to develop an answer. Again, we'll do a 2-minute response for this. We're going to start first with Judge Joanna Tabbitt. Judge Tabbitt, you're up first and you have the floor.
Sure. And I think that the court is doing some good things, certainly with respect to the treatment courts. I'm a big advocate for drug treatment courts and the presiding judge of the juvenile drug court. And I think that if you can divert those nonviolent offenders, I think we all recognize that addiction is a brain disease and that incarceration is not the answer for nonviolent offenders. The courts need to do what they're doing as it relates to family treatment courts. I think that is a very good process, certainly helping to keep the family together when you can do that safely. But I think what the court needs to do is continue to work with stakeholders, that being the DHHR, other social service organizations, recovery communities, and law enforcement to work to, also the legislature, to work together to see what we can do to combat this crisis and its residual effects, frankly, on the abuse and neglect cases that we see in circuit court.
Very good. Thank you for that response. Next up will be former Justice Richard Neely. 1 minute, sir. Okay, you have the floor. Go ahead.
I don't have any great expertise in this particular area. I know that drug court is successful to the limited extent that it is successful, because you have a black-robed, honest-to-God judge presiding. And that gives the whole operation a certain elegance and prestige. It's very difficult, however, to get people who don't want to be rehabilitated into rehabilitation. It seems to me that about the best program for rehabilitation in the drug business is the Narcotics Anonymous. It follows the same structure as Alcoholics Anonymous, because the first step, the person must come in and say, I am a drug addict and I need help. And that's about 50% down the road. So I think that the fact that there's a problem doesn't necessarily mean that there's a solution. We probably want to devote our resources to the people who genuinely want to be freed of the drug addiction. And to the extent the courts can do that, I'm all in favor of it. To the extent that the courts are spending a lot of valuable court time doing something that could as well be done by a master's level psychologist or a counselor, I think that we're wasting resources.
Very good, and thank you for that response. Next up will be Attorney Chris Rains. You have.
So, oh, I'm sorry. So, I am a fan of the treatment courts. While I embrace them, I also think that there needs to be accountability, and just helping the ones who want help, I don't believe is going to solve any problem, because not only do addicts continue to crave narcotics while they're in jail, but once they get out, they almost reoffend immediately, to the point that they're almost using what they were using before they went in. They're dying, they're stealing from their families, their friends, and their community. So that doesn't really solve the problem of just helping the ones who need help. We also need to give them some kind of incentive. And again, I think that the treatment courts are a good incentive. I know as a prosecutor, I do a lot of what we consider hybrid pleas, which is that I will offer a plea to a person to a felony for admission into a drug and treatment court. And in exchange for that plea, we will withhold the adjudication of guilt until that treatment court can be completed. That way, that person knows that if they do complete that treatment court, that felony may be reduced to a misdemeanor. I think in some jurisdictions, it may be dismissed completely. That way, that person can know that they don't have a felony on their record. They can continue to work. They can continue to pay taxes and be very beneficial to the economy and to society. But that is also a carrot and stick analogy that seems to work in our treatment courts. I think that where we're failing in the treatment courts is that the aftercare program, we kind of graduate them from the treatment courts, and then we look after them for a month or two, and then they're out on their own, back in the same environment where they were when they were using drugs. So I would like to add additional supervision, some job training, and some counseling during that aftercare program, maybe even up to 6 months or a year, to where that person can get assimilated with a recovery program and recovery lifestyle, and will have the skills to be successful in that recovery.
Very good, and thank you for that answer. Next up will be Chief Justice Tim Armstead for a response on that.
Well, thank you. But this has been an issue that I've certainly been working on long before I started my term on the court, and certainly during my time as in the legislature, I created in the legislature the Select Committee on Substance Abuse and Treatment. We have been having pieces of legislation go all over to different committees, and because of the problems that we were dealing with addiction, we felt it was important to have a particular committee that looked specifically at this issue, and I created that in the legislature. And I did so because really there are three different things, three different parts of this problem. First of all, it's what can you do to stop people from getting addicted in the first place? How can we reach our children, make sure they have different choices in life, and they realize the negative effects of getting addicted in the first place? Secondly, for those who want to do trafficking of drugs in our state, we need to treat them. We need to have laws in place that stop that trafficking in our communities. And then thirdly, we need to deal with those who have become addicted and want to free themselves of that addiction. And so there are three different parts of this puzzle, I think. And it's hard, I think at times the state has focused too much on one part to the disadvantage of the other two. We need really to be dealing with all three of those parts, I think, simultaneously. And the court has a role to play in each of those, probably more so in terms of the dealing with those who have been, charged with drug trafficking, and those who are dealing with the addiction. And we've talked a lot about this evening about how the family treatment courts really get to the heart of that problem, one of which is the accountability. If you say, let's say you have a situation where someone is going to lose their children because of an addiction, and they are judged an abusive or neglectful parent, and that's that, and then they get this improvement period, 3-month improvement period to try to fix the problem. If they walk out of that court and they don't see the court again for 3 months, often they don't do very well with that improvement period. They need that accountability, which family treatment courts provide, and which drug courts provide for those involved in criminal cases relating to drug abuse. So I think that it's important. It's time consuming for that court. They talk with them every week. And I've gone and listened to several instances where either the participants are graduating from drug treatment courts, or they're participating in the family treatment courts, or they're coming before the court. I've really invested a lot of my time trying to hear how these work and view them in action. And I think they're very successful for those who want to succeed, so to speak. And what I have seen, and I'll wrap up with this, I think ultimately those people who succeed, whether they're in drug treatment court, family treatment court, they have to be motivated by something in addition to the court, either their faith, and they trust in their faith to help them. They want to rebuild a relationship with a spouse or a child or a parent, and that motivates them. They want to succeed at a job or a career, and that motivates them, but something has to motivate them. And I think it's important for us to try to help them find what that is through our probation staff, through our counselors. And I think drug courts help that, but I think in every court, they need some additional resources in terms, I'm not talking about money, I'm talking about necessarily the community involvement, the counseling involvement, to try to help reach the core of what issue is causing that person to be addicted and help them free themselves from that addiction. And I think the court can play a crucial role in that.
And very good. Thank you for that answer. Give me one moment there. Next up will be Justice Hutchison answering the same question.
Thank you. Judging has changed an awful lot in the 25 years I've been in the system. When I came on in 1995, a judge was a judge, and he sat up and he handed out consequences and dealt with cases, and didn't deal a lot with what went on before or what happened after he pronounced his decision or sentence. The courts have changed immensely in the last 25 years, and we are now recognizing that judges and courts have an obligation to be more than mere arbiters, especially in cases dealing with children and in criminal cases. And I said it earlier and I'll say it again, there has to be a consequence for conduct. And if somebody commits a crime and there's got to be a consequence, but we don't want to see those people again. And that's where the community involvement comes in through the use of veterans courts, family treatment courts, drug courts, both adult and juvenile drug courts. And the other thing that other folks haven't mentioned, and something that we need to work on a little bit, and I think the prestige of the court can help, are community correction centers. Because those types of community centers can get involved earlier than when we get to either the entry of a plea or a conviction or something like that, where we're trying to kind of encourage somebody to go in. Because if we can get people into treatment courts, into treatment centers through community corrections, either as a condition of bail or something like that, we have a chance to get to those people earlier. And I can't tell you, and I know that Chief Justice Armstead has been in a number of adult graduations from adult drug court, and I've been in a number, and we've each heard people saying it took 2 or 3 times for me to fail before I realized there was something different. So just letting people self-report to Narcotics Anonymous or Alcoholics Anonymous, that's good, but you can't forget those few that you may catch by putting them early into these treatment programs. And that's what the court has to do. Hold people accountable, but also give them an avenue to get out of where they are. Thank you.
Very good. Thank you for that answer. Last but not least is Jim Douglas. Mr. Douglas?
The Greek concept of hell in classical studies was to roll a round rock uphill and constantly roll back down. And for all eternity, you had to roll it back up. I think that the opioid crisis has come to resemble the rock in the courts and the society, or resemble the repentant person in that particular type of hell or Hades. I practiced law for 39 and a half years, mostly family law, and I tried 2 FIG cases, that's infant guardianships family court, in all that nearly 40 years. That's 1 every 20 years. Now as family court judge, I probably average, at least before the pandemic slowdown, probably 5 a week. Sometimes there's more, sometimes there's less. And everybody's addressed about, how we approach the opioid crisis. I can't add a whole lot to that. But other than this, I think we also have to pay attention to the cause and the effect, because this crisis doesn't exist just in the universe of the addict. There are children affected. Right now, I see more grandparents than ever, not a grandparent right case, people coming in and applying for guardianship because mom or dad are addicted and no longer present. And there's no incentive there. They just hand the kids over to the grandparents and then they go on their way. The guardianships, do you make those harder? No, the kids suffer. Do the guardians have, like the grandparents have, any financial resources? If they don't have their own, they're not being helped out by the state of West Virginia because they're not really foster parents on the one hand. So we have to keep in mind, in any type of approach to opioid addiction, we have to deal with the victims, not just the addicts, the victims of the addiction that are collateral. The other thing of it is, on the other periphery or the other side of the pendulum is who helped cause this. I think we have to hold doctors accountable. That's been recently done, that overprescribe. I think we have to hold mid-levels responsible, that since 2017 have had a greater latitude in prescription. I know they don't go above usually Schedule 3 substances, but nevertheless, there are some substances in Schedule 3 that are habit forming. And then also, I think we have to hold the manufacturers liable that flood, for example, McDowell County with millions of pills, an inverse ratio to their population. It's not just the addicts. It's the people that cause it and the people that suffer from the addiction other than the addicts. That's really all I got to say.
Very good.
Thank
and
you.
Thank you for that. Now I'm going to pass over to Kyle McAvoy, who's going to moderate the next question from our bank.
Thank you very much, everyone. Before I turn this question over and read it aloud, I'm gonna go ahead and give you the order so no one's caught off guard. We will start off with Attorney Raines, then Chief Justice Armstead, then Judge Tabbitt, Justice Hutchinson, Judge Douglas, and then last with former Justice Neely. So this is kind of a multi-part question, but with the legislature redrawing West Virginia's congressional and legislative districts in 2021, if challenged, what factors would you consider in determining the constitutionality of those districts? Do you believe that the West Virginia Supreme Court has the legal authority to redraw the districts as was done by the Supreme Court of Pennsylvania? So we're going to start with Attorney Raines. Give me just a moment here, please. Okay, the floor is yours.
Thank you. So in West Virginia, the factors that need to be used in judging the constitutionality of redistricting are, is it compact, meaning does it, are there minimum distances between all the parts of the constituency? Is it contiguous? Are all parts of the district being connected at some point with the rest of the district? And does it preserve political subdivisions? I do not believe that the court should be legislating from the bench as to and activating those redrawing lines. I think that is purely a legislative function, and I would not interfere with that at all, like the court did in Pennsylvania. In the League of Women Voters versus the Commonwealth of Pennsylvania, the court held that the legislature, if it is unable to or chooses not to act to remedy an unconstitutional congressional redistricting plan, it becomes the judiciary's role to determine the appropriate plan. I think that is a clear violation of separation of powers. I think that that needs to go back to the legislative function. That is a federal and a state legislative function. As long as all states comply with the federal constitutional requirements of the population, and to make sure that it is not discriminatory. I actually looked over that case from Pennsylvania. I agree mostly with the dissent in that case. It rang true to me when Justice Bayer from the Pennsylvania Supreme Court said that the court's remedy in the majority threatened the separation of powers by failing to allow the other branches sufficient time to legislate a new congressional districting map. Again, it is not my role to stand in the place of the legislature. It is my role as a justice, if elected, to look at the constitutionality, the factors that I just explained that are in play for redistricting. And if it does not meet constitutional muster, then it is our job to send it back to the legislature to make sure that they do their job.
Thank you very much. Give me just a moment here. We're going to turn it over to Chief Justice Armstead. Give me just a moment to get you unmuted there. Okay, the floor is yours, sir.
All right, thank you. Well, let me just say up front, I want to be a little careful about answering this question for one reason, and that is if I am fortunate enough to be on the court and there is a challenge to a redistricting map that is drawn by the legislature, it would come before us. So I'm not going to talk about what I think the court can or can't do, because I just don't think that's appropriate for me to say we would do this or that or should do this or that. But let me say this. I do think I can talk about in general the crux of the question, which is what does the court look at when it deals with these issues? And historically, one of the things that has developed over the last 5 to 6 decades has been, how do you impose and ensure the one person, one vote standard is truly followed constitutionally in a redistricting plan? And you've had a recent challenge before the United States Supreme Court about whether you count all citizens or only count adults who could vote and those types of questions. So a lot of that has been decided by our United States Supreme Court, and certainly we would apply that precedent to any challenge that comes before us, if one should come before us as a court. Let me say this now, stepping back from before my time on the court. I've been in the legislature for 2 different redistricting processes. After the 2000 census in 2001, we were engaged in the redistricting of the legislative and congressional districts when 9/11 happened. So we were actually in a special session when that happened, and we had to take a break from that process and then come back and do that. And then we did it again after the 2010 census. And it is largely now, in terms of being able to determine the size of a district and whether it is the one person, one vote principle is really followed. It's largely computerized, so that you move census blocks from one district to another, and then this computer tells you, are you in variance, so to speak? You can be 5% above or below whatever for example, in the House district, you take the population of West Virginia, you divide it by 100. That's an ideal House district size, and you can go 5% above or below that. If you go outside of that, you're outside of variance. So there are some very constitutionally based principles that we would need to follow and ensure that are followed in any redistricting plan. And we would do that. And, that again, it is a legislative function to do it. But again, the legislature has to do it constitutionally. And I think that would be our role, would be if in fact this a plan is or is not constitutional, that would be what we should review.
Thank you very much. Appreciate the answer. We're going to move on to Judge Tabbitt. If you give me just a moment. Okay, you're live.
Thank you. And I'm going to answer this question a little bit differently. I mean, as I understand it, the question is, in essence, how, if I were elected to the Supreme Court, would I apply constitutional principles as it relates to legislative redistricting? And I think everyone has indicated that obviously that's something the legislature is going to be doing. But what I do have to tell you is that the Code of Judicial Conduct, and it's different. Obviously, judicial candidates and judges have different rules. And the Code of Judicial Conduct prohibits judges and judicial candidates from offering opinions regarding matters that could potentially, in issues that could potentially come before the court. So I don't mean to be dodging the question, but I don't think it's appropriate pursuant to the code to respond to it more than what I've said. So thank you. Again, I don't mean to be begging off of it.
No, that's fine. I appreciate that. We turn over to Justice Hutchinson. Give me just a moment. Hey, you should be unmuted.
Okay, thank you very much. Again, must be extremely careful on how you respond to this question. The second part of the question, Rule 4.1 of the Code of Judicial Conduct, I believe, precludes me from answering that question because I would be commenting on things that are going to come before the court. As to the first part of the question, the factors, clearly what you do is you apply or you uphold the Constitution of the state of West Virginia and the Constitution of the United States, and you look to all the issues that have been addressed. Stare decisis is very, very important in this matter, and there's been a lot of guidance given by the Supreme Court of the United States. That's where you look, and then you look at exactly what the challenges are, and then you apply and you ensure that to the best of your ability, that one person, one vote applies. That's about as far as I think I can go.
Okay, I appreciate that. We're going to move on to Judge Douglas. Just a moment here. Okay, the floor is yours, sir.
I have a different take on the ethical responsibility about this particular issue. There's a case called White versus Minnesota that was decided by the United States Supreme Court in 2002 when there was attempts made by judicial candidates or the court in the state of Minnesota that tried to proscribe through the canons, justices being asked their opinions on certain issues. And I'm of the opinion that as this question is posed, you're asking an academic issue. You're placing an academic issue in front of us, not a real live controversy. And the way I understand White versus Minnesota is that I can't refer to an existing case. I can't refer to a case that has, identifiable factors in it, or one that is imminent. As an academic issue, I speak right to it. William Brennan, who was on that activist court in the 1960s, was asked one time what he thought his most important contribution, what his most important case was while he was on the court. And everyone thought he would talk about, Brady versus Maryland, or they thought he would talk about Miranda versus Arizona, or Gideon versus Wainwright, or some of those cases. And he said, by far, it was Baker versus Carr. The case that came out in 1962. And that's probably one of the few times that he and William O. Douglas agreed on something. What that is, it is not a separation of powers issue. That's a secondary consideration. That is a structural political argument. The constitutional question is equal protection of the laws. If you drew a line around straight across Route 50 in West Virginia, so it's through Clarksburg, Romney on, and you're doing congressional districts, that's where one of the obligations is to draw it out, and that makes it a federal issue as well, is that one person's vote north of that Route 50 line has to be equal as nearly as possible to a person's vote below that line. That means if there is less population below that line and they're voting for one congressional representative, and there's more population in Wheeling and above those areas, then the vote that is below the line is worth more numerically than someone that is above the line. And that is an equal protection issue. The Pennsylvania cases that we referred to earlier, that League of Women Voters versus the Commonwealth, it followed two other cases called Holt 1 and Holt 2 that had to do with the state assembly. The League versus the Commonwealth had to do with the congressional drawing of the maps. And this is a federal issue. It also, you have to look at one other US case. It was Grove versus Emerson that came out in 1993. That's not really that old in federal law. And that where it says that there's an equal protection mandate. The federal courts have to defer to the legislatures and or the state Supreme Courts. And if they don't do the job consistent with equal protection, then the federal court has to draw the line. So it's an academic exercise. Anytime after any census, 2020, 2030, 2040, the West Virginia court has the second responsibility after the legislature. The legislature is unwilling and unable to act. The West Virginia Supreme Court has to do it as an academic problem. And if they don't do it, then it goes then to the federal district courts probably to draw those lines. But what you have to look at is there any deviation? Is there an acceptable deviation? You can't have gerrymandering. You can't take like a Republican county and split it up and put it in 5 counties. You can't look at an area that's primarily one minority group and split it up and put it into 5 or 6 different legislative groups. So that's what the real crux of the matter is. And then, secondly, there's another case called the Midland, Texas case came out of the United States Supreme Court. There can be a deviation up to anywhere from 12 to 15%. All right, thank you.
Thank you very much. Just a moment here. We're going to turn it over to former Justice Neely. The floor should be yours, sir.
Well, I agree with Justice Armstead, Judge Tabbitt, Justice Hutchison, and Judge Douglas. So that takes care of that.
Okay. We're going to move right along here. I believe we're going to maybe turn it over for another Facebook question. Let me see if we can, I believe Ethan may have a Facebook question ready for us. Maybe not. Okay, we can go right along to our next question of that we have planned. I'm going to turn it over to Paula Martinelli so she can ask the next question. In just a moment here.
I can unmute Kyle. There you go. Okay. So I actually have a two-part question for you all, but it's an easy one, which is why do you want to be a justice or continue to be a justice? And what administrative experience is your background, in your background, has helped you to, or would help you in this role? So why do you want to be a justice, and how has your experience, or will it help you in the role? First up is Judge Tabbitt. Let me unmute you. There we go. Go ahead.
Thank you. Thank you, Paula. And you know, it's really simple. I've lived in West Virginia all my life, and I ran for circuit judge and ran for public office initially because I wanted to use my training and experience to help West Virginians. And that's why I want to be a Supreme Court justice. I believe that now more than ever, we need to put qualified judges on the Supreme Court, judges with circuit court experience that have an experience with the breadth of issues that the Supreme Court sees. I have been a circuit court judge for over 25 years, in a courtroom litigator. I'm sorry, a circuit court judge for over 5 years, and a courtroom litigator for 28 years before that. And I spent my life in a courtroom. And I have sat on the Supreme Court by special designation. I know how to do that job. As it relates to administrative experience, last year I had the, I'll say, privilege of serving as chief judge in the state's largest and busiest circuit in Kanawha County. I was over at circuit court judges, family court judges, magistrates and their staff, and managed the probation and juvenile probation and adult probation as well. I have experience in my private practice of law and human relations and employment issues, and was a partner in one of the largest law firms in the state for 20 years before I ascended to the bench, and managed the litigation department of over 50 lawyers, paraprofessionals, and administrative staff. So I have not only the legal experience, courtroom and judicial experience to do the job, but I also have administrative experience as well.
Thank you very much for that answer. Next is Judge Chris Raines. There you
I'm
go.
not a judge yet.
Sorry.
Here's hoping. But as 20 years as a criminal prosecutor, I have prosecuted hundreds of cases, and I too have lived in a courtroom for the last 20 years. But I do think I bring a fresh perspective to the court by not only being able to remember the litigants, remember the rules of law and the rules of evidence, criminal and civil procedure, but also by remembering the victims, because these people I've met firsthand. I've dealt with them. I've held their hands. So I definitely think that I can bring that perspective as being a fighter in the courtroom for the last 20 years. As far as the administrative experience that I have, I've worked in 2 different prosecuting attorneys' offices where I've acted as the senior trial attorney in charge of training a lot of the younger prosecutors. I've also taught for the National District Attorneys Association for the last 12 years, where I go across the country teaching young prosecutors trial advocacy skills to prosecute their cases in their jurisdictions. I've also served as a city prosecutor in 2 municipalities during the last 10 years, where I provide training to the officers in criminal procedure, and I'm also involved in making charging decisions on tough cases.
Thank you very much for that response. Next up is Justice Armistead. Please go ahead.
Okay, this is probably the
Yes,
question.
I'm sorry.
Can you hear okay? All right.
Mhm.
Thank you. I've had, it's hard to put into words what an honor it is to be on this court. As an attorney practicing almost 30 years in our state, and to look into the reverence that I've had for this court, to be on the court now and to be in the court when it was going through a tough time, and to be able to, I believe, play a part in trying to put it back on the right track is just a tremendous honor. And I care about the court, and I care about the future of this court and making sure that it stays on the right track. In terms of administrative experience, it's kind of been, another justice asked me, said, did you really think you would become Chief Justice right in the middle of what we've been going through the last 2 months? And obviously not. But I've had two really honors in my life in terms professionally, in terms of my service in government, and one being 20 years in the legislature and 4 years as Speaker of the House, and then to be a Justice and Chief Justice. So I've had an opportunity that only about a dozen or fewer people in our state have had to actually lead two branches of our government, serve in a leadership role in two branches of our government. And so I think that experience of having been the Speaker and administering the House of Delegates for 4 years really helped me to be prepared for the challenges that we faced over the last couple of months of trying to bring people together. It's been sort of a running joke of trying to herd 100 members of the House is like herding cats. I didn't really feel it that way, because I thought you had a lot of people who really wanted to, whether I agreed or disagreed with them, wanted to do the right thing for the state. And I think we have the same thing now with judges throughout our state, circuit judges, magistrates, family court judges, our probation, all the different parts and roles of our court that play such a significant part. And it's an honor to be able to lead in this branch of government, and something I really enjoy. I enjoy the administrative part of it. I enjoyed the administrative part of being Speaker as much as I enjoyed the part of making laws. Here I enjoy the administrative part of being the Chief Justice or a Justice of our court, as well as interpreting the law and deciding the cases and deciding them fairly. So I think that my experience really has been a tremendous help to me in this role. One that, not only spending 20 years making the law of West Virginia, so I understand sort of why words are put where they are sometimes, or what the legislature may be thinking when they decide to do not a particular bill that I had anything to do with, but just any piece of legislation that comes in front of us. And we talk a lot about circuit judges moving up, but I also think there's a huge role for people who have legislative experience serving on our court, because so much of the role as a judge, as a justice, is to look at the law, determine whether it's constitutional, and interpret it in the way that you believe the legislature meant for it to be interpreted, and just to follow the rule of law, as we've talked about. So I do think my experience as an attorney, as a practicing attorney, as a legislator, as a justice over the last 18 months, and as Chief Justice this year have really come together to be able to allow me to, I believe, do what needed to be done in those roles.
Thank you for that response. Our next response is from former Justice Neely.
I've worn everybody out with my criticisms of the existing court structure. And so my main reason for running is to try and fix that. As regards administrative experience, once upon a time as an Army captain, I got plucked out of the artillery and placed in charge of all of America's economic development efforts in about a quarter of South Vietnam. I ran the economic development program. I then came home and I had a term in the legislature, which, as Justice Armstead says, is extremely useful. And then thereafter, I've served 5 years as Chief Justice of the West Virginia Supreme Court of Appeals, all of them after the Judicial Reorganization Amendment, when the Supreme Court was responsible for the entire judicial system. Past that, I've had various experiences in business, running things, but that's about it.
Thank you for your response. Next, we have Judge Jim Douglas. Hold on, let me unmute you. There you go.
I've been holding on patiently. Well, why I'm wanting to run is revealed in some statistics. Let me give you a couple, 3, 4 here. There is one divorce every 13 seconds, over 277 divorces per hour in this country. In the time of an average wedding reception, which is about 5 hours, there are 1,385 divorces filed. There are in red states, you're 27% more likely to be divorced than in a blue state. There's nothing magical about that. But then 50% of all children will witness a divorce. West Virginia, the civil appeals in 2017 were 64% of all civil cases. In 2018, it was 64%. In 2019, it was 58%. So if you don't elect somebody that has family court experience to the West Virginia Supreme Court, then you're missing more than 50% of the cases, at least being able to bring that experience to the table. There's nothing magical about being a circuit judge to be on the Supreme Court. I know Justice Neely here was not a circuit judge. Chief Justice Darmstadt was not a circuit judge. Justice Cleckley was not a circuit judge. Harshberger, Miller, none of those people were circuit judges. Yet they're some of our best judges that we produced in this state. I've done everything. I've tried boundary line cases. I have tried condemnation cases, slip and fall. I tried car wrecks. I even tried in Braxton County one time a goat kill case where some dogs got in and killed some prize goats. But anybody across this panel here, nobody's got this experience that I've got in family law. And that's more than 50% of the cases. That's more than 50% of the cases at all. It's my obligation to run. I wish somebody else would do it. It's my obligation. There's never been a family court judge that has that history that sat on the Supreme Court. There's not a family court judge in this entire esteemed panel. Isn't it about time to do that? Especially when we have all these kids out there and we have all these divorces. The other thing is West Virginia is tied. Here's just my final statistic. It's tied with the state of Wyoming presently at 7th in the nation per 1,000 people and not per capita, per 1,000 people over 15. Since 2008, there have been occasions we've been 3rd. And we've usually routinely run anywhere between 5th to 7th. That's in 50 states plus the territories. That militates in favor of having somebody with family law experience. Now, what administrative experience I have? I've run a law office. I ran a law office 39.5 years. I was prosecuting attorney for 4 years when we had to deal with budgets and I had to deal with personnel. I've been a family court judge where we've had to deal with administrative matters, not only personnel, but trying to make 5 judges work in Kanawha County. You don't know what herding cats is. That's more, like herding gophers or she cats. I've been on the State Bar Board of Governors for 2 terms where we worked with the state bar budget, the 2 3-year terms. Right now, and I have been for the last 11 years, I've been an officer and on the board of directors of West Virginia Symphony. We've dealt with $1 million budgets and a myriad of problems. And I say now is the time to bring that family court experience, that overall well-rounded experience onto the court. I'm not doing it. Everybody says they want to be on the court for transparency or they've had a dream or they don't want to buy couches. I can say all that, but it's not a dream. It's an obligation for me to do that because in the next 12 years, there's a chance there will be no one on the Supreme Court with any family law experience. Do you want your divorce or your grandchild that you're trying to get visitation with to be watched over and wooed on by somebody that's never either had those relationships, number one, or number 2, have not tried those cases? I've tried more grandparent visitation cases than anybody sitting here tonight, or more divorces. That's all I got.
Thank you, Justice Douglas. Last on this question is Justice John Hutchison, or that is where I was, wasn't it? So I think we finished that, and I'm going to turn this back over to Ethan, our co-chair.
Paula, I do think that we did miss Justice Hutchison. I didn't see, that was Judge Douglas there. We're going to come back to Justice Hutchison for his
Okay.
response to that question. Sorry
Thank
about that, Justice.
You got confused because I was usually last.
Yep, the floor is yours.
Well, thank you very much. It's really easy for me to answer the question of why I wanted to be a justice. A little history to it. You know, I was a lawyer practicing and trying cases in the circuits of Southern West Virginia for 15 years. And then I made a conscious decision to make a career change and become a judge. And I sought out appointment and I was appointed by the governor to a seat where the local judge had retired. And then when all that took place in 2017 and 2018 took place, I was embedded in a system that I trusted, that I had great respect for, and that I thought deserved great respect. And then when everything happened in 2017, 2018, and then with the fallout that took place in the late 2018, I realized that I had an obligation to try and become involved and fix the system that I had dedicated my life to. It was, you know, judges make a conscious change in a career path when they become judges. There are not many judges that leave the bench and go back and have a successful career. One notable exception, I guess, would be Justice Neal, who's done fairly well. But historically, that's not the case. So it's a career change. So I got involved and wanted to be a justice because I wanted to make sure that I could do what I could to repair a broken system. And I think we've done that. Now, administratively, I've got a lot of experience that everybody else has. I was in private practice and I was a partner in a law firm. I had to manage a law firm, make payroll, pay the taxes. The very first case, I will say this, Jim brought it up a minute ago. The very first case in which I ever filed an official pleading was in United States tax court. So my very first case out of law school was in United States tax court. But I fortunately didn't have to try that case. But in any event, you take a look at what I've done over the years. 7 times in the third busiest circuit in the state, which is Raleigh County, 3rd or 4th, sometimes it falls. I've been chief judge 7 times. Again, I had charge of the magistrate clerk's office, the clerk and all her employees. I was responsible for all the magistrates and their assistants, dealing with the sheriff, making sure all the bailiff programs and everything were all together, dealing with our community corrections programs, trying to administer those. I had that. When I came on to the bench, very early, 1997, I was appointed to the mass litigation panel, and I was a charter member of the mass litigation panel and served on that until I became a justice in 2019. I had responsibility for the only case that's ever been tried by the mass litigation panel, which was the flood case. Took 8 weeks to try, in excess of 3,000 plaintiffs, 260 defendants, and I had to manage that case. After I left my private practice, I went to work for an insurance company and opened the trial division office in West Virginia for Nationwide Insurance. Started with me and a telephone in an empty room. And 4 years later, that was a 6-man law firm handling 600 to 700 trial cases a year. That's all we handled were trial cases. I've tried any number of cases. I tried, managed administratively and closed nearly 22,500 cases in my 23 years on the bench. So I've got significant experience in administering the business of law firms, the business of being a judge. And then the last 18 months or 17 months, I'm sorry, Tim's got 18, I've got 17. I have been responsible for assisting the other 4 justices in administering 1,500 employees statewide. So I think I have got more than appropriate administrative experience to handle this job. Thank you.
And very good. Thank you for your answer. We appreciate that. And we thank everyone for joining us tonight. We've tried very hard with all of these virtual town halls to keep them around 2 hours, and it's now 9:08, so we're right at the 2-hour mark. We're going to move on now and go into our closing statements. We'll be a little bit lenient on our time there. Our order for that will be Rains, Neely, Tabbitt, Douglas, Hutchison, Armstead. So we'll have 2 to 3 minutes there for that response. Again, we'll be a little bit lenient on that time. First up will be Attorney Chris Rains. And there you go, Chris. The floor is yours.
Thank you so much for this opportunity, for this forum. I've enjoyed participating with these judges and justices tonight. I appreciate this opportunity to talk to voters, because the chance to talk to voters during this unusual campaign season are few and far between. Remember that had we not had COVID-19, we would have been voting tomorrow. So we do have another month. I'd like people to visit my website at reinsforjustice.com to see what I'm about. Again, I'm the sole conservative in this race. I hold conservative values endorsed by the West Virginia Republican Party, as well as West Virginians for Life. I would be honored to have your vote on June 9th in Division 2. Thank you so much.
Very good. Thank you for joining us tonight. Thank you for your time and your patience. Next up will be former Justice Neely.
Well,
there you go. The floor is yours.
it really has been a pleasure to be here tonight. I've enjoyed meeting everybody that's on the ballot with me face to face. It's the first time we've all had an opportunity to be together. So it's been very nice. I have basically said everything that is worth saying, and it's getting late. So I'll say thank you very much and good night. As Edward R. Murrow used to say, good night and good luck.
Very good. Thank you for your brevity, and thank you for joining us tonight. We certainly appreciate your time. Next up will be Judge Joanna Tabbitt.
Thank
Judge
you all.
Tabbitt, there you go.
Thank you all very much for the opportunity to connect with voters. I have been for the last couple months, campaigning from my couch in essence. So this is a very pleasant opportunity to see everybody and talk with everybody. But, I'm committed to helping lead the court in the next generation. And I showed my commitment by filing my pre-candidacy papers for this race about a year ago. Everybody else that got in my race got in the last day, the deadline of filing. And I think the distinction that is that basically other folks may see this as a process and an opportunity. But for me, it's a commitment. It's a commitment to the rule of law. It's a commitment to the betterment of the judiciary. But most importantly, it's a commitment to the people of the state of West Virginia. And I've got endorsements from law enforcement, first responders, medical association, business and labor behind my candidacy, because I think that they recognize that commitment and have an appreciation that I have the integrity, work ethic, and experience to lead the court into the next generation. Again, I appreciate the opportunity to be here. And I want to emphasize, though, how important and historic this race is, because in June, we are going to be electing. The voters of West Virginia will be electing a majority of our Supreme Court. That's 2 12-year terms and 1 4-year unexpired term. That is 28 years, an entire generation of jurisprudence. So it is critical to put the right people in those positions. And I look forward to being one of them. Thank you.
Very good. Thank you for joining us. Again, we thank you for your patience sticking with us this evening, and thank you for your thoughtful and thorough answers. Next up will be Judge Jim Douglas. Mr. Douglas, the floor is yours.
It's been a long process. It's been a long process. I ran in 2018, and then on June 6th of 2019, I filed my pre-candidacy. I'm looking ahead, and I'm looking for the culmination of this race to be successful on June 9. I'd ask each of you all, as you sit around thinking tonight, and everybody that's watching, how many people do you know in your circle of acquaintances that has had a felony or had contact with a felony, somebody in your family? Have that number in your mind. Then think how many people in your family, your circle of acquaintances, have been involved in divorce, grandparent rights, child allocations, domestic violence, LGBTQ issues, which have never been mentioned tonight at all. All right. And grandparent fights, guardianships. I think that number will be a lot higher, very much higher. People that sit around their kitchen tables drinking their coffee in the mornings all around the state of West Virginia, they're not interested in whether or not there's an intermediate appellate court. They're not interested in whether or not there's a metro government. They're not interested in mass tort litigation. They're interested in whether or not a grandparent's going to get to see that little grandchild's in the midst of some divorce somewhere. They're concerned, a single mother is concerned about whether or not she's going to get her child support and get it on time. A divorced father who has 2 children and his ex-wife all of a sudden decides she wants to leave Braxton County, Kanawha County, Wood County, Hancock County, and move to the state of Oregon with those 2 kids, whether or not they'll ever see them again. These are the things that people in West Virginia are concerned about. The COVID-19 it's a great equalizer. It doesn't care about who you are, your family, your pedigree, your religion, your gender, your affluence. Same way about family law. It affects everybody. It touches everybody. So you need someone in there that's had that experience. I wasn't from a big law firm. I never tried to be in a big law firm. I've never been a slave to any insurance company or anything of that nature, or personal injury firms. I didn't seek endorsements. I filled out the questionnaires. I thought people ought to know where I stand on things. But the thing about endorsements, you always wonder how they're going to be paid for, how they're going to cost, what that cost is going to be. And if you're on the opposite side of somebody in front of a justice or a judge, any judge, that's had those endorsements and they're a party, you wonder about their impartiality. I would. It's time now to elect somebody to the Supreme Court that has a family law background. And do you think that you would be interested, somebody having a family law background on the Supreme Court, if your case was up there, if your alimony issue was up there, your grandchild was up there, or the visitation issues, or an LGBTQ issue, or domestic violence and what you're going to do? I think you need somebody up there that's been down that road. It's time, I think, don't you? Go ahead. That's it.
Very good, Judge. We thank you for that time and thank you for joining us this evening. Next up will be Justice John Hutchison. Justice, you have the floor.
Thank you so much, and I appreciate everybody that's listening in or watching tonight on any of the variety of platforms. The first thing I want to do, my dad was a gentleman in all aspects, and always thought that things should be done properly. And one of the pieces of advice he gave me in the only other election I had, which was in 1996, I've run unopposed since then. But the one thing he said to me was, John, never assume and be polite enough to ask. And so I'm asking for all your votes. I ask each of you personally. I can't make eye contact with you as I would like to, but I ask each of you for your vote. what you've got when you look at me is you've got somebody that has made that commitment to doing the right thing and having paid the price. Commitments in my situation don't get paid for. I appreciate somebody indicating to me that they support me, and I have support from, I have it from business side, I have it from first responders, I've got it from law enforcement, the medical association, the West Virginia teachers. I've got it. I lost some because of a decision I made, which I felt was the right decision. But having said that, what you've got is somebody that has done this job for 25 years, and I've done it at both levels. And I've done a lot of family law work because a lot of the cases, I don't know whether it was unique to my circuit or not, but a lot of the family judges got appealed a lot. So I had to deal with those issues, especially in terms of divorce, and especially in terms of grandparents' rights, and especially in terms of domestic violence petitions. So I've dealt with all of those. Plus, I've dealt with everything else, including abuse and neglect, juvenile law, huge juvenile practice. Whenever I started the truancy court in Raleigh County, first year had 675 petitions the first year, dealing with juvenile issues all over the place. So you've got somebody that has closed an enormous amount of cases, and that doesn't, you know, the 22,500 I mentioned a minute ago does not include all the mass litigation cases I closed. So I think what you have is somebody that has the experience, has gotten the ability to sit, think, and make correct decisions based on the law, and somebody who is dedicated to this system and dedicated to restoring this system to the place where it was before I got there, and meaning in Charleston. So I ask for your vote and your consideration. Thank you very much, Mr. Chairman.
Very good, and thank you, Mr. Justice. We appreciate your time. Last up will be Chief Justice Tim Armstead. 1 minute, Mr. Armstead.
All right, well, thank you. I don't want to, me being the last one between us being finished, I want to try to be brief, but let me just say this. I can't say enough how honored I am to have had the opportunity to be on this court and to be a part of a historic transition on this court. You know, I don't come from a rich background or any, you know, politically connected family. I'm the first person that really has ever been involved in government in our family. And I've always taken it seriously that it's an obligation. It's an honor. It's people put their trust in you and they expect you to go to the Capitol and do all that you can do to make their lives better. And that's what I've tried to do in 20 years in the legislature. It's what I'm trying to do now on the court. And I must say that no disrespect to my colleague, but I don't think there are trash cases, because to the people that are litigants in those cases, they're about their life, they're about their future, they're about their children, they're about their freedom. There are all kinds of different issues that we take up, and to each one of those individuals who are our fellow West Virginians, it's incredibly important. And I take it with that approach in mind, that it's incredibly important to those people. And it may not be an earth-shattering case that sets precedent for the future for years and years, but it is important to them. And we affect in this court whether people are sentenced to life imprisonment, whether they are lose their children, whether children have a new beginning to be able to be in a safe, loving home. We deal with all different types of issues that affect people where they live. And we need justices who take that seriously, who want to follow the rule of law, want to respect each of those litigants, and want to do it humbly and with integrity and with hard work and efficiency and respecting the taxpayers' dollars in terms of the administrative part of it, and people who want to follow the Constitution and the rule of law. And I believe I fit that description. I think I've shown the people of West Virginia that I do over the last more than 20 years of service to our state. And I would be deeply honored to be able to continue the forward progress that we made over the last 18 months on our court. It is incredibly important. We're going to go forward with this court or we're going to go backwards. There's no in between. There really isn't. And I think we need to go forward and keep the momentum going in the way that we've put our court back on the right track in the last 18 months. Be honored to serve as your justice. Thank you for giving me the opportunity to be here and be able to reach out to folks. It is a different way to campaign, and I wish we were able to be with people, and we will be someday, hopefully in the near future. But until then, I appreciate this opportunity. So thank you.
And very good. Thank you for that. And thank you to all of our candidates, ladies and gentlemen, for joining us. We appreciate your time. I'm going to switch one just here at the end. We like to do a gallery view and let everybody wave goodbye as we end the virtual town hall. So everyone who's joined us tonight, we appreciate it. All of our viewers, thank you for being with us. And everyone else, good night and thank you for watching.